The Johannesburg High Court is due to hear the matter between Jacqueline Mbambane, Amanda DuPont and Masichaba Ndlovu at this hour. The matter was brought on an urgent basis by Jub Jub's mother, also known as Mama Jackie, to have DuPont and Ndlovu remove their social media posts in which they claim they were raped by her son, retract statements that she used Umoti, and also be interdicted from making public statements about her. We speak now to Mr. Mabu Marweshe of Marweshe Attorneys. A very good afternoon to you, Mr. Marweshe. These proceedings are due to start any moment now. They were scheduled for any moment now. Is that still the case? Is this case still on the roll for today?
Good afternoon, Sister Stanley, and to your viewers. Yes, correct. The matter is scheduled to resume now. It can start at any time. It was stood down for this afternoon because there was an application that we understand was brought by the media houses so that they can be granted permission to televise the proceedings.
And what is the status of that application?
The status of the application as it is that it will proceed. It's opposed. We have opposed it. As you've mentioned, the application is brought by the applicant, which concerns the lawfulness of the statement that were published by both our clients. And the application is in two parts. There is a part A that is before the court, which the applicant claims that it is urgent. But we have opposed that. We filed our answering papers on Christmas Day. We filed our heads yesterday. We have opposed the matter on the basis that it simply just lacked urgency because we are all aware as to when these statements were made public on social media. But the applicant decided to come to court probably 3 weeks later, claiming that the matter is urgent. But we are actually convinced that the order will be granted in our favor on the basis that the matter lacks clearly urgency.
So give us a little bit of background regarding this particular case.
A bit of the background, it's premised on what is already in the social media. As I've mentioned, the application is brought before the court by the applicant, who is well known as Jub Jub's mother. We were served with the papers on Wednesday last week. So the application raises issues of lawfulness of the statements that were made by our clients and published on the social media. Therefore, the applicant is claiming, with reference to those statements, that they are defamatory in nature and that they have placed her life in danger. But there is no evidence that is actually supporting the allegations that have been made by the applicant in the application. Hence, we moved with our papers that the matter should be struck from the roll with cost for lack of urgency.
Just going back to the initial questions, you very graciously went into the details of your application, which is appreciated as well. I was going to get to that. But the status of the media application as it stands now, has the media been given permission to be able to broadcast these hearings live?
On our side, we have informed the judge that we have no objections in media televising the proceedings. We do not have any position or a view that's been taken by the applicant in this matter, but we have already informed the judge on our side. But I have no doubt that the judge will grant an application in favor of the media. The matter is simply in the public interest. I don't see why even the applicant would actually oppose to that.
So going back to the merits of this particular case, what exactly is it that Jackie Mbambane is demanding from Amanda DuPont and Masichaba Ndlovu?
Her application rests on what I would call on two grounds. One is that she alleged that the statements that were published by our clients are defamatory in nature. Therefore, the court must order our clients to remove those statements from social media. And the second one is that the statements have actually placed her in danger. But as I've mentioned, there is no evidence to support the second leg or even the first leg that the publication of the statements are actually defamatory or they have placed her in danger. Therefore, we don't see why the judge shouldn't strike this matter from the roll at all with cost.
What Ms. Mbambane says is that these applications or these statements, as you've said, are defamatory and that they are untrue. Will there be a process then of getting into the assessment of the statements of whether or not they are indeed defamatory or if they are based on any fact?
Depending on how the judge will approach the matter, let me just give you an example. If the judge agrees with us that there is no agency in the matter, the judge will simply not go into the merits. The applicant might then have an opportunity to place the matter on a normal roll. Later on next year, the matter will be heard, and then the merits of her application will be dealt with. But if the judge is satisfied that the matter is urgent, then the judge will grant the parties an opportunity to then go into the merits and argue the case, and the judge will then hand down the judgment later on. Or even the judge might hand the judgment today after the matter has been dealt with in its entirety.
What is it that goes into determining whether or not a matter is urgent?
Look, there are various issues, but one of the issues that normally take priority is the rules of the court. We have Rule 6, Sub-Rule 12, that requires the applicant to prove that they might not, in the ordinary course, obtain a substantial relief if the court or the judge is not actually considering the matter on an urgent basis. But in this matter, we simply submit that they have not even met the test of Rule 6, Sub-Rule 12. We also have case laws that have been decided in the past. Some of the case laws that we've cited in our heads of arguments, they include the UDMA case, which is well known. But on the basis of, at least on a bare minimum, on the basis of Rule 6, Sub-Rule 12, they simply have not even met the threshold, and therefore their matter should be struck from the roll.
All right, then. Well, thank you very much for that update. We certainly will be keeping abreast of developments on that front. Will it be struck off the roll or not? Will there actually be a hearing into this case where the merits will then be discussed? Thank you very much for your time, Mr. Mabu Marweshe from Marweshe Attorneys.